So my responsibility this morning is very simple. It's just to introduce our discussants. And I didn't get your bios, but the first discussant is Dr. Sena. Dr. Sena is our lecturer at the Faculty of Law, Egerton University. And Dr. Sena is mainly known for his identity on matters human rights and especially to do with the indigenous communities. Sometimes we call him the Ogiek lawyer because he has done a lot of work with the Ogiek and the indigenous communities in Kenya. And the other discussant is Dr. Hayundi. Where is Dr. Hayundi? Dr. Hayundi started with us at the Faculty of Law, Egerton University, and later on moved to Riara University before he moved to United States International University, USIU, where he teaches matters to do with law within the area of international relations. And that's it. Then I would like to call them to come to the podium, and perhaps as they confer among themselves who will take over first, I am going to, I don't know what national anthem we have on matters to do with human rights. Perhaps the DJ can just play for us Giuliani's song, Utawala, as Dr. Sang or Dr. Hayundi comes to the podium. You have the track, DJ. Dr. Sena, karibu, take over.
Thank you so much, Mr. Kioko and everyone for being here for this very, very important exercise that we have at the Faculty of Law. As you all are aware, it's the first one. My work is very easy today. I'll lead the discussion and invite people to speak. But then following up on what had been discussed yesterday, starting with the presentation from Professor Kamere, then Professor PLO Lumumba, and all of you, I captured a few things. First of all, the decolonization of the entire legal system, a very, very important thing. And then the whole aspect of clinics. And I hope that that will serve as a basis for the discussions going forward. And since we are already behind schedule, I would want to really take this opportunity to invite Lady Justice Teresia Madheka, the judge of the High Court in Nakuru, to give her opening remarks, and then we continue with the program. Karibu Judge, tumpigie makofi.
Good morning. Hamjambo. Ladies and gentlemen, all protocol observed. Today I'm really honored to be here attending the first ever National Legal Aid conference on a topic or on an issue that is at the heart of access to justice for all Kenyans. And I know that we are gathered here to discuss or to have a conversation on how to strengthen access to justice through legal aid. Discussions will be had, on policy, practical issues, the achievements we've had, the challenges, gaps, and opportunities to accelerate that aid. And today we can celebrate, I think it is one of the singers, Sikumbuki ni nani, alisema haujui kule tumetoka. I think there's a song like that. And up to where we are today, that we have a Legal Aid Act and we have jurisprudence that says that the right to legal aid is a fundamental right for every Kenyan. We can celebrate that. As I speak today, I want to draw from my experience as a magistrate. And because when I was asked to come to speak, my topic was really to concentrate or really speak around the issue of legal aid and juveniles in the justice system. That is mambo ya watoto ambao wanajipata katika mkono wa sheria na wanahitaji usaidizi wa wakili. I think anyone who has sat in a magistrate's court will know or will be aware of what happens there. And if some of you can remember the holding of Lord Denning in the case of Pet versus Greyhound, and allow me to paraphrase, because he spoke about issues of having an advocate speaking for you. Allow me to paraphrase that quotation, kwamba si kila binadamu au mume au mke au mtoto, even wakili, ambaye ana uwezo wa kujitetea kivyake au kibinafsi mahakamani, huenda akashindwa kujieleza au kueleza kesi yake kwa njia inayofaa kudhibitisha hiyo kesi yake. Pia huenda akashindwa kuonyesha udhaifu wa upande ule mwingine wa kesi ya kesi ya upande ule mwingine, au kueleza au kuonyesha uzito wa kesi yake. Akiwa pale mahakamani, huenda ulimi ukapata kilo ukawa mzito, akapatwa na wasiwasi, akapigwa na butaa na mshangao na kuchanganyikiwa, na hata wakati mwingine akili kupotea. Huenda akakosa ujuzi wa namna ya kuwaelekeza mashahidi wake au kuuliza maswali. Kila siku, every day, utaona hakimu anamuuliza mshtakiwa, una swali la kuuliza? Na mshtakiwa ataanza kutoa hotuba badala ya kuuliza maswali. Ikiwa haki itatendeka, huyo mshtakiwa anahitaji lawyer. All I'm saying is that the judge was simply saying that in any court, you will find a person who has been charged with an offense being unable to express themselves. When asked to ask questions, they start giving speeches. When put in a place where they need to defend themselves, they start telling stories. And if justice is to be done for that person, then they need the help of a lawyer. So what about a child who finds herself or himself before any court? What happens to that child? And I'll give you a story. I've told this story many times. Some of these stories have become my precedents when I speak about legal aid to children. I am sitting in a rural court somewhere in Western Province, and I'm taking plea. And behind the witness box, or the accused person's dock, there's supposed to be an accused person. So I call the name, and I can't see the person there because he's so tiny, I can't see him. And I look at the charge sheet. He's charged with, I think it was arson or setting fire to crops. And I ask, where is the accused? Only for the little boy to walk out. He's 8 years old. And what happened when you listen to the story? He was left at home. Some of you who come from Western know that some years ago, sugarcane would be planted up to the doorstep of people's homes. So he's left at home by himself, and I think he was either trying to warm his lunch or something, and a fire started, and it started, caught the cane outside their door. And before he knew it, the fire was burning the whole sugarcane in the whole village. So who do they arrest and charge? The little young boy. There is no lawyer in court at that time. Luckily, the next time the matter came, there was an advocate in court, and I asked him to represent him. So you can imagine that kind of situation. Or the other story of the boy who was shot. I'm sitting in Kibera Law Court. I'm not the one who took the plea, but someone else did, and today is the hearing date. And what happens? The young man comes there, the matter is supposed to start for hearing, and I ask him, uko tayari kuendelea, are you ready to proceed? And he starts crying and telling me, no, I'm not ready. What happened? Oh, the police shot me. You were playing somewhere. I was shot. The next time I found myself in a hospital bed at Kenyatta, they operated me. He opens, takes out his shirt and shows me a scar down his chest. I am in Nairobi, remember, and it is the place where I used to hear, because that was my first time to work in Nairobi, that their legal aid was available to children. We used to hear about it when working in the rural courts. But there's this boy here, he has nobody. And interestingly, even as we sat in court, no one offered to represent him. I've told this story before, some of you know it. And what did I do? I decided to test the myth of Section 77(1) and 86 of the Children's Act. Remember, children have always had legal aid in the law since the year 2001. And curiously, no one had ever gone to court to test those provisions, whether they actually worked. So that particular day, I took down the complaints of the young man, and I came up with a ruling and gave directions that the DR up there should allocate this young man a lawyer. In my view, by that time we already had Article 50, Sub-Article 2, G and H, that tells us that if substantial injustice is going to occur in a matter, then the court can direct that the person be given a lawyer. And here I had a child. I was very much aware that any person who is charged with murder, adults, people like you and me, who will sit down and plan, would get a lawyer simply by appearing before the magistrate, before the judge, and they automatically get a lawyer to represent him. Here I had a young man charged with robbery with violence. He had a story that was so terrifying of what had happened to him. He was denying the offense, and he had nobody to represent him. So my letter went with an order that he be given a lawyer. But as things would be, what I got was a reprimand. That there is no provision at that place for provision of lawyers or legal aid for children from that kitty that is provided for persons who are charged with capital offenses. Many stories like those abound in our country where that happens. And today, even as we have the Legal Aid Act, we still needed the circular of the Chief Justice recently to remind people that we need to allow children, to give children who appear in court legal aid. Legal aid for children who come into contact with the law, on conflict with the law, is like the hand that holds them to the door of access to justice, which is the place where they can be heard if they have a lawyer. That is the place where they can have, a podium like this. You open the door, legal aid holds your hand. If you're a child who is in conflict with the law, in contact with the law, to a podium where you can be heard. Also to the space where their rights can be exercised. And also to the space where there is a floodlight. It means there's a lawyer somewhere where any violation can be scrutinized and the duty bearer be brought to book. So we have provisions of the law. We have Section 77, Section 186, and Section 184 of the Children's Act. But for a long time, as I've said before, those have been paper rights for children. And like I said earlier, we also have now the Legal Aid Act, but we still needed a reminder that for children, somebody somewhere was not doing their job, and the CJ had to remind us that we need to do the right thing. But what form of aid, what form should legal aid come for children who are in conflict or in contact with the law? If you look at the provisions of Section 18.4 of the Children's Act, they speak about that when a child is arrested and detained, he will need legal aid and other assistance to have his case done. And the question itself is that why was that provision put like that? That a child will need legal aid and other assistance. And if you look further at the Children's Act, Section 114, and I wanted to ask the people gathered here, because you are practitioners, whether any one of you has ever asked or gone to court to apply for an order, a Section 114 order, under the Children's Act for any child. Section 114 is the provision of the law that talks about the judicial orders that a court can make to protect a child. And two stand out for me: the Child Assessment Order and the Family Assessment Order. Because read together with Section 18.4 of the Children's Act, you can see why the law speaks like that, that for children, it is not just legal aid alone. It is legal aid and other assistance that comes hand in hand with that. Why do I say this? Because legal aid for children must respond not only to their legal needs, but also to the other social needs of that child. Why do I say this? Because when you look at our children's law, it is that a child offender is first of all a child. And we are required not only to look at his legal needs, but also at his welfare as we deal with his case, his or her case. So that just after the provision of the law that talks about us giving this child legal aid, we are also required to look at his or her best interests as we deal with this case. So that as much as the child offender, a child who has committed a crime, the thing that we are called upon to look at is that he is a child first, and we must consider his welfare as we deal with this case. And what are we required to do? To look into where he lives. We must look at when this child was entering the system, where was he coming from? Okay? And again, also secure his welfare, his maintenance, his education, and his training. So when you're providing legal aid for a child, you are not just looking at his acquittal at the end of the day, or his being found guilty. You must have a goal. You must have a goal that you intend to achieve with this child. That is the requirement of, if you read the law properly, that is the requirement of the law. And what is that goal? When this child leaves the system, when this child who is a child offender leaves the system, what is going to happen to them? So a lawyer providing legal aid for a child, whether, and let me say this, whether watching brief, or whether representing the child, or, and I dare say, even prosecuting the child, despite the fact that ours is an adversarial system, when it comes to children, I think we are called to look at it differently. We must be able to look at that in the context of the family, and that's what the law tells us, and in the best interest of the child. This lawyer who's representing this child, and I see this sometimes that, especially in the High Court, I found maybe a child is charged with murder, and there's a lawyer representing them, but by the time the matter is coming for, some mention or something, that child has not met his lawyer. So if you're coming to court and you haven't met the child, how are you going to represent his interests? Because you must know what is in his best interest as you are representing this child. Because his interests start from the moment he gets into conflict with the law. So pre-trial, he needs a lawyer. That's why the Children's Act says that at the moment the child is brought to the police station, the police officer ought to call either the parent, a social worker, or an advocate. And when this lawyer is providing this aid to this child, they must be able to be accessible, because the kid will have questions. One of the problems I've seen is that even when an advocate is appointed by members of the family for a child, that it is more that, what I see is more that the child, the advocate is, representing, listens to the family, to the father or the mother, but the child is the client. And therefore, the advocate must be able to know that his approach to providing the legal aid must be age appropriate for that child. Otherwise, his best interest will not be taken into account. And then, I've mentioned earlier, legal aid for children must be multidisciplinary. I remember asking Dr. Aura, do you have people from other, Mr. Mbua, from other, not just lawyers, like the social workers, the probation officers, children officers? Because when you are going to represent a child, it is more than just, like I said, their legal needs. If you're going to look at their social needs, then you will need, are you willing, are you ready, are you prepared to consult with the other persons to be able to give this child the wholesome legal aid they need? Then, of course, it must be effective. I had mentioned about the goal that you will be having for this child. What do I intend to achieve? Because the courts have spoken. For example, you watch brief for a victim of a sexual offense. The person is convicted, he goes to prison. Si ameenda jela. That's the end for you. But we know the courts have said there is compensation. Yes? It's available. You can sue for compensation for this victim of this offense. So why stop there? This child goes away. The person has been convicted. But remember how the process of prosecuting a case or being a witness or being a victim in a court matter is very traumatizing. So what is in it for that child? At the end of it, how does she feel or he feel that justice has been done? So we need to look at it from another point, that as much as there's satisfaction that this person has gone to prison, there is more to it than simply that. These children, why it is important for it to be multidisciplinary. You have a victim of a crime. For example, I'll give you an example. The girl who the father was the one who defiled her. The man went to prison, but the uncles and aunts are saying, father is in prison because of you. So when you leave, because you have finished your case, what happens to that kid? So we need to, to refocus our minds and see how do we make legal aid or legal representation for children meaningful, because they really don't understand these things. I remember one of them, we had to make orders for one to be taken to foster care, and another one for whom it was forced early marriage. The fact that the marriage has been declared unlawful, but the husband who has paid cows and they have not been returned somewhere out there, you are told in court that should this man find this girl anywhere, she's still his wife. So he can carry her away and disappear with her. So what do you do? So when we are doing this, let us remember that for the children, it is more than just ending in the courtroom. That's why it must be multidisciplinary. You must be able to go out there and consult with the other persons who might help you. For this other girl, I've just mentioned, we had to put her in witness protection for a while because that was the only place she would be safe for a while. And then, of course, it must be responsive. I've mentioned that children have more than just their legal needs, and they are the social needs that come with them being in contact or in conflict with the law. So, having said that, I just wanted to say a little bit about where that brings us. If we are going to look at legal aid as more than just the legal representation in court, that brings in all the other children who find themselves within the court system or within the system of justice. Because we are saying that we want to strengthen access to justice for children who get into contact or in conflict with the law. Who are these children? Can we define them? And I have small stories, like the intersex kid who finds herself in my court and nobody knew what to do with her. You know? So that the court now is forced to descend into the arena to find something for this child. Or the one armed baby. There's an echo somewhere. The one armed baby whose mother was attacked by the father, and he cut her thumb, and in the process, cut off the baby's arm, from here, because he was angry with her. And then the mother comes to court and says, I want to withdraw the case. Separating the interest of the mother, who has feelings for her husband, and the interest of the child, who has lost his arm, and nobody will ever explain to, because he's about 15 months old, ever explain to him where his arm went or what happened. The court should be able to have somewhere where the court can say, this baby here has different rights, separate rights, from the mother, and he needs a lawyer to represent him, now that his mother is acting in a way that could, violate his own rights. Of course, in that case, again, you find that one way or the other, because it's a child and the court can do so many things for a child, the court was able to just say, no, you withdraw your claim, but we are going to continue with the one for the child. Or the boy who was afraid of elephants. Here was a father who was charged with an offense. He came to court, he was a single father, came to court with his child, sent him to prison, and the next thing you hear in court is wails and screams. How am I going to go home? Who is going to stay with me? There are elephants that pass outside our home and my father has gone to prison. He's a child who has come into contact with the law by because of his father's own actions, and now he's there, a child in need of care and protection without anyone to take care of him. Or the street children that are rounded up and dumped somewhere. Yeah, is that familiar? Yes? I don't know whether anybody has gone to court. And we heard of 2 incidents, one in Nakuru and one in Eldoret. Some, we are told, died and they never showed up. They have never been found. Or children who find themselves in court with mental illnesses and special needs. A child commits a crime, but within our law, there is no provision that we can have any child who has committed an offense automatically be taken before a doctor for mental assessment to see whether, they were in their right minds. But an adult who plans a crime, kills someone, has the right to have their mental status checked as of right, and you cannot take their plea. So we need lawyers who can be able to raise these things for children, because we have those kids in the system, and they end up actually going through the system and becoming adults committing these crimes. So what do we need at the end of the day? We need advocacy for accountability and creating awareness among children. I know that we do it in many other ways, because if a child knows, they'll demand for it. If the child is aware This is my right. I don't know whether whether we have a way of saying, if you're arrested now, Mr. Wambua, can you tell a police officer, I demand my Article 50 sub-Article 2 G and H right? Can you say that? Yes, is there anybody who is able to say that? Prof. You know, good morning. Because we need to have such an awareness that nikishikwa na polisi saa hii, because it is in the Constitution, and the courts have said it's my fundamental right to demand for a lawyer, that I should be able to tell the officer, siongei kama wakili wangu hayuko hapa. So where should this go, this advocacy? Not just the children need to know, of course the families need to know, and the police need to know that a child can tell the officer, mimi siongei kama wakili wangu hayuko hapa. We need to find a nice phrase for that Article 50 sub-Article 2 G and H right of asking for a lawyer, or that Section 43, you know, so that we can hold people accountable. Of course, the courts have been held accountable, the lower courts have been held accountable in the recent decisions where trials had been declared mistrials because the court did not inform the accused person that they had a right to ask for a lawyer. You've read those judgments, I'm sure. So if it is in the books, where are we not? We should go out there and tell people, unaweza kusema hii, so that we don't wait until there is that problem, you know. And then, of course, raising the consciousness of people about children who commit crime. They are children first, because we have this attitude of that a child who commits crime is a juvenile, delinquent, and mambo yake kwisha. But you know, even our Children's Act removed the term juvenile from the law. Now we only have children who infringe the law. They're not even accused persons. They infringe the law. In fact, that's how the Children's Act describes child offenders. A child who infringes the law. And children who come into contact with the law. So we don't have juveniles, because somehow it has that connotation of some stigma of a bad child who maybe mambo yake imekwisha. Educating the JOs, that is judicial officers and ourselves, and raising our awareness on what we can do. And where there are lawyers who are willing to provide legal aid, then they be available to do that. And of course, jurisprudence, we need you guys to come to court. Nahitaji mawakili wakuje kotini to actually find ways of, you know, the courts to make those clear to people. What do these sections mean and what do they, you know, especially for children matters. Children will need legal advice, ushauri, you know, to be represented and to be assisted, not just them per se. If, for example, I talk about the mother who lost her children. A dispute arises between two parties, two partners or two families, and the children are taken away from the parent. That mother, those children need their mother. That mother needs legal aid on behalf of our children. So when she comes and saying, nahitaji kusaidiwa nipate watoto wangu, we should not see the mother per se, but see that there are children out there who have been taken away by people who need to come back to the family. They will need help in resolving disputes. Now we have ADR. We have AJS. We have mediation. Some matters that come before the courts can be dealt with that way. So they will need this aid to be able, usaidizi, to be able to, you know, resolve the disputes out of court and also have those disputes settled. Of course, for us to be able to make legal aid effective, when people know it is there, they'll ask for it. Of course, the school outreaches and community outreaches. And as I've said earlier, bringing on board other stakeholders, the police, the children officers, probation officers, even prison officers, because children pass through the hands of all these people and they need to be aware if a matter arises. You have seen, for example, a lot of matters that have changed the jurisprudence on the rights of people who say are incarcerated or have been sentenced have come from people in prison. Francis Muruatetu has turned, has brought a big turn in the way we look at criminal matters. Not just the death sentence, but on so many other issues. But children may not have, they could be in those remand homes and having something to say that they have seen, they have experienced, or in the Boston institutions. But until an advocate goes there and they share their experience and they say what they are going through, then we will never know. And I am sure if we approach it just the way we approach the adults, then we will get something out of that, to be able to strengthen the way in which we provide legal aid to children. And maybe finally, just to say that legal aid, in my view, when it comes to children, of course, and other people, it's an Article 19.2 issue, where we talk about recognizing the fundamental human rights of every person, protecting or preserving the dignity of everyone, and a matter of social justice. So that when you talk about legal aid for children, how do we make them feel, the feeling, your feeling too, that they are equal before the law? If you visit rehabilitation schools, I don't know how many of you have been to any rehab school in this country. Anyone? Yes, and spoken to those kids. They will tell you stories that make you cry, and you wonder, are they really telling me the truth? How some of them have ended up there because they didn't know what was happening, or their parents conspired with someone to have them put there. Why shouldn't that child who says, my father conspired with an officer and so because I was being difficult and brought me, I'm finishing, and brought me to this place? And of course, the issue of being able to realize their full potential. Any child who is in contact or in conflict with the law and finds themselves within the system still have that right to be able to realize their full potential, but only if they have a hand to walk them through that door of access to justice through legal aid, to be able to say that I too natosha kuwa na haki zangu, because at the end of the day, haki ya mtoto ni jukumu langu na wewe na kila mtu. Asante sana. Thank you.
Thank you so much, Justice. I think all of us really appreciated her intervention, her keynote speech, and she has raised a number of very, very interesting issues. What is justice still remains the most debated question, given the examples. Are all of us in the room, do we have that courage to act, test the system, to put into practice what is in the paper, as she has demonstrated through what she started doing? Legal financing challenges. Who will finance these legal aid activities? She will also mention something to do with the multidisciplinary nature of legal aid, the need to have effective legal aid, and how do we achieve that, raising consciousness, advocacy, and etc. I think during the discussion we'll discuss many of these issues because they build on the whole discussion that we had yesterday. So in the interest of time, I would like to invite our next speaker, who is Flora Bidali, to speak on the evolution of legal aid in Kenya. Karibu sana.
Okay, good morning. My name is Flora Bidali. I'm from the National Legal Aid Service, and my topic today is on evolution of legal aid in Kenya. As he prepares for projection, I can continue. Now, to this, our being here, we have touched a lot of what is already happening under legal aid. So when I talk of the changes that have taken place, a lot has already been mentioned. If you look at the evolution of legal aid in Kenya, we need to go back many, many years ago. Societies in the world had conflicts. These conflicts were inevitable due to differences in interests of goals, values, and their aims in society. These conflicts that arose were either within families, clans, villages, or even from one country to another country. And the legal aid systems within law usually applied to address the conflicts that arose. The systems within Kenya have been there, and the legal system is accessible, the formal one, accessible by only a few due to many impending factors. The legal aid mechanism has been viewed as a strategy to address conflict, but with limited application. Still. Now, what is legal aid? It comes in different forms. It can be the legal advice, legal representation, and assistance in resolving a dispute, maybe through alternative dispute resolutions. Institutions that we have in place are therefore vital in addressing the conflicts within communities in Kenya. However, this legal aid remains limited and continues to exist for only a few people. But there's also legal aid outside the formal legal framework. My paper today highlights the role of legal aid in Kenya around the conflicts that arise and how this has evolved over time. Yes. Okay, now, before colonialism, we talked of this earlier. I think Professor Mbote talked about this, but in a different context of colonialism. The African communities cohabited mutually and in a manner that addressed conflicts in a non-formal way. This was without resources, because currently we are talking of not being able to have funds to address conflicts for those who cannot afford. In the old days, the elders took pride in addressing conflict. Where there was a fine, the compensation was used only as a means to acknowledge the wrongs done and to restore parties as much as possible to where they were before. Then comes the legal system, which streamlined only a few people to address conflict resolutions, meaning only a few people could have access to this system. The court systems working started to centralize the court chambers, meaning again, only limited people could access this. The challenges that were are in place or were still in place as it came up is the court fees that are introduced, the geographical location. If you go to Tana River, they have to travel so many kilometers to get to a law court. I think there's no law firm in Tana River that we came across when we were there about a month ago. Then the complexity of rules in the formal system, the languages used, there's a myriad of challenges within the formal system. Now, prior to 2010, the government then came in to see how the indigent persons can be assisted in having access to these formal systems. Justice Matheka has just talked about the Children's Act. It was ignored for a long time. Now that we have the Legal Aid Act, we talk of access to justice now being available. But then we forget legal aid was already there, but in a different form. It was not being acknowledged as legal aid when we are writing our papers, but in practice, it was there. Then we also had international conventions, like the rights of a child, that guarantees every child deprived of his or her liberty prompt access to legal services. Now, the process of developing this legal framework started in 1998 with the Attorney General's office. Around 1999, a committee was identified to come up with a piloting scheme to create awareness, and it proposed a rolling out of these services. Around 2002, the then Ministry of Justice gave policy directions in the area of access to justice. The ministry then set up weekly legal aid clinic every Wednesday at the Ministry of Justice. All the state councils were required to provide legal aid services on Wednesdays at Ministry of Justice. That's the bell-bottom house. Now, it was out of this that they had to change the strategy because of the overwhelming demand. Then came the National Legal Aid and Awareness Program, which piloted the services that were being rendered only at the Ministry of Justice offices. Offices were opened in Nairobi, in Nakuru, Eldoret, Kisumu, and Mombasa. This went on between 2009 and 2013. What we have under the 2010 Constitution highlights the vital principles of access to justice. Every individual was granted access to justice by using both the formal and informal systems. ADR was viewed as a social fact from which society derives some benefits. Arbitrators or mediators selected, and in this piloting, these services, the mediators are key in creating access to justice. Now, the provisions under the 2010 Constitution goes further, that individuals that cannot afford legal representation have to be assigned an advocate at state expense. So you see, the evolution continues to take place, and we are making big strides in access to justice. Now, we have the Legal Aid Act. Then how do you talk of evolution of access to justice under the Legal Aid Act? The values and principles set out in the Legal Aid Act will be a big step in, I don't know what's happening. The values that are stipulated under the Legal Aid Act are a key step in emphasizing the evolution that has taken place over time and to reach us to where we are at the moment. The Act regulates the provisions of legal aid services and establishes the National Legal Aid service. I can't move the slide. Can someone? The slides are not moving. Okay, you've taken me elsewhere. Now, what does the legal aid service do? How are we going to talk of the evolution of legal aid in Kenya? The Act has mandated the National Legal Aid Service to strengthen the framework of policies, laws, administrative processes that will ensure sustainable and quality access to justice in Kenya. It's expected that the services will be of a good quality, effective, timely, and representation of the poor, marginalized, and vulnerable. Then again, NLAS is expected to enhance access to justice through legal aid awareness, to promote and institutionalize the paralegal approach to access to justice. I know paralegals have been chastised many times, saying that maybe the quality of legal aid services will be lower, but without the paralegals, from research that has been carried out, we will not be able to move as fast as we would like to move. We do not have adequate advocates, and the Act has brought in paralegals to see how we can enhance access to justice. Then also, there's to promote the use of alternative and traditional dispute resolution mechanism, then to establish an implementation, monitoring, and regulatory framework, and to allot physical, human, and technical resources to legal aid and awareness services in Kenya, and also undertake research to ensure evidence-based initiatives. Now, the Kenyan justice systems are regarded as inferior in comparison to the formal justice system. A lot has been said here about our cultural way of addressing disputes. If we view the informal as inferior, then we will be limiting access to justice. We look at the formal system again as inferior when we look at our cultural practices. Yesterday, I was privileged to share a thought from Professor Lumumba, where he talked of the Kadhi's court being told they cannot address matters that deal with children in the Kadhi's court. That is a way of looking at our culture as being inferior to the formal system. So, looking at our culture where we can practice and address certain matters, and also accommodating the formal system, will be a way of enhancing access to justice, and we'll see access to justice evolving in a way that we'll all be able to access the system that is in place and make this a better place. Thank you for that.
Thank you so much, Flora Bidali, for taking us through the evolution of legal aid in Kenya. I'm sure you'll have a lot of questions for her on how you can be an effective part of the entire process. But in the interest of time, our Honorable Justice needs to leave, so I want to take, I want to give her 5 minutes to answer 1 or 2 very pressing questions that you may have about all that she discussed when she was here with us. The first question goes to
Shemukanga. All right.
And then who else? Let me see 2 hands. And I want agenda balance. Professor has a comment that's going more than 5 minutes now. Huh? Yes. Okay, 3. All males, okay?
All right, can I go ahead?
Yes, yes, yes.
Thank you, Honorable Lady Justice Matheka, for the practical remarks on the importance of legal aid in the court system. In light of your wise thoughts, allow me to pose a question. Professor Ranbir Singh, in his book, Access to Justice and Legal Aid Services for People with Special Needs and the Underprivileged, he points out that the judge, through his authority, has a crucial role to play in ensuring legal aid. Judges, through their vast experience, have a sixth sense to know when a party needs legal aid. And in light of these quotes and remarks from this professor, don't you think that the judges or the judiciary has a primary role to play in ensuring that legal aid is provided, even by requesting lawyers in court? Thank you.
Thank you so much.
Okay, thank you. Thank you very much, Lady Justice. I need more indulgence on something that you have said that have awakened my thoughts. I'm aware there is the issue of the Children's Act removing terms such as offenders, punishment, and the rest. Then I've heard you say that juvenile, the term juvenile was also removed. Then looking at even curriculums all over, not only in the legal courses, but also sociology and the rest, our universities still have a unit by the name juvenile justice. So what is your take on that? Thank you.
Thank you. Let's make the question short, sharp, and focused, as the professor told us yesterday.
Hello, my name is Chantel. I have had experience with working for the Cradle, the Children's Foundation. And my question to you goes to towards the Victim Protection Act, which is ideally supposed to be providing for compensation within the criminal setup instead of just having to go to a civil court to receive compensation and have a child, placed in an institution where they can be cared for and so on. What has been your experience with that? Especially because I know that a lot of our prosecutors don't actually, invoke this act. Yeah, that is my question.
Thank you so much. And last is Professor Abule.
Yeah, thank you, Honorable Lady Justice Teresa Matheka, for your insightful presentation. Mine is a comment on your observation that there are gaps in the legislative framework regarding to the procedure for referring a child offender for mental assessment. My view is that the High Court, is the only court in this country which enjoys unlimited original jurisdiction. Section 22 of the Children Act gives the court unlimited original jurisdiction to do whatever it's necessary to protect the rights and welfare of the child. So mine is to say that our judges should have the courage to use the jurisdiction conferred on the court to break new ground and shed new light, because we may not be able to prescribe everything that needs to be prescribed in the rules, but the judges can develop rules of practice emanating from their own understanding of what is the proper thing to do to protect the interests and rights of the child. So as practitioners, we would just urge the judges to have the courage to break new ground and give us rules of practice from precedent and case law. Thank you.
Just a minute, please. Due to public demand, Professor PLO wants to say something.
No public has demanded, but but I want to say something. There is something that Professor Mbote said yesterday, which I think ought to be unpacked, and I'll invite her to do so. That when you formalize the informal, and I'm using the word informal very loosely here, then you lose its true flavor. And you have traveled to different parts, and you've given quite a number of incidents about the arson thing and other things. And this varies. If you are in West Pokot or in Bukusuland, how you resolve one issue, if you think in a binary form, binary to mean the formal and the so-called informal, then you miss the point. But I want Professor Mbote to unpack that particular issue for us, because it then informs how we approach legal aid. Professor Mbote.
Thank you very much. I think yesterday, in a very abbreviated way, I talked about the fact that our Constitution allows for a plural legal system. And once you allow for a plural legal system, you must allow the system to engage the norms, the structures, the actors, and the interests in the diversity of legal systems. And and this may be my radical view, is that as lawyers, we come to justice with colored glasses. We come in to make access to justice what we understand it to be. And how we should actually approach informal systems is actually going to learn. When I was talking about us learning anthropology and sociology, I wasn't talking about them as good to do. I was talking about them as things that lawyers may need to go and be enmeshed in a society to understand how people understand justice. Because our understanding of justice, if we ask people around this room how we understand justice, it's different. So if we have to make people within what we call informal justice systems access justice, we must understand what justice is to them. Otherwise, the foundation or the architecture on which we are building legal aid is fraught with fractures.
Thank you so much, both of you, for such a very interesting comment. What is justice is a question that remains in our minds. Okay, Johanna.
Thank you very much. Is this on? Well, thank you about that, Prof. And it is so true. If you allow me to just add a comment to what she's saying. At one point while I was at JTI, this AJS thing was just coming on, and I remember attending a training. Okay, let me not call it a training, but we were just having contact with elders in the different communities to see if they could be brought on board on this AJS. And we attended one in Garissa, I remember, and my role was just to discuss with these elders the place of Article 27 on non-discrimination, and the place of children and women when they are discussing, when they are solving disputes. And one of the things that we were trying to say to them is that, if one thing you cannot do is discuss sexual offenses when you are resolving disputes. And one elder asked me, who is a child that we cannot discuss a child in our sittings? Who is a child? We discuss very big things, important things. We deal with murder cases. We deal with cattle rustling cases. We deal with all these other land disputes. Why would you tell us we cannot discuss an issue related to a sexual offense related to a child? Of course, my other lenses, of course, came on, and I had to tell them what I think about that. Of course, at the end of the day, it was up to them to decide whether they were going to be part of the system that we were looking at, whether they would proceed with the way they were doing things and be kept off from dealing with, from participating in that court-annexed AJS system we were looking at. So it's a really difficult situation when it comes to some of the communities that are really set in their ways, and there is conflict and violation of the rights of the parties who maybe will need to appear before them, or their cases will be dealt with by them. But I do agree that they need to be allowed to, to grow. coming to the questions, maybe the comment by Prof about Section 22, our system is such that someone must move the court, to declare what that provision says. And I think that has been the problem with the Children's Act. Now we are making a new one, but if you read the Act, you'll find there are so many provisions that have never been applied even or tested on a single date, including the ones on legal aid for children. So if a court is moved, they will make the appropriate declarations. But I do agree that now, actually Prof will agree with me, courts have taken a very courageous path of saying things as they are. We don't shy from saying things as they are as far as the rights of our people are concerned. The question on the primary role of judges in just knowing whether a person requires legal aid. I can tell you that that is done on a daily basis. I call it self-help, And just to give 2 examples, one of them happened, the people who are in Nakuru know the Juvenile Justice Project that we had in getting lawyers to sign up when there was no money to represent children. And I remember in Nyahururu, we set up just a legal aid project where lawyers just agreed. You sit with them, you talk and say, there's no money, nobody's going to pay you, but I feel strongly that I need you to help me to give justice to these people. And there were 11 advocates in Nyahururu, that time, and they all signed up. And all we needed to do was, a child case is filed, and we just refer it to the advocate, and he appears for no payment at all. And it worked for the years I was there. I was there for like 4 years, and every single day there was a child's case. There was an advocate available for no pay to represent that child, and even other child-related matters. So as much as we have that, of course, the limitation of who is going to pay. And that was saying the children's right under Section 77 and 96 were paper rights, because it said there, monies, anyone who represents a child will be paid by monies provided for by Parliament. But there was no fund. So if I asked a lawyer to represent a child on the basis of that provision of the law, where would I get the money for them to be paid? So we had to go another way of saying, please do it, and there's no money. So there's also that challenge that for as much as judges and magistrates know and are aware that someone needs a lawyer, for as long as the law says that someone needs to be paid, they'll be expecting their pay. But then there's the other part where someone will volunteer and say, I'll do it for no pay, which is not very easy to do. So I agree with you, and I think that's my answer, that where it has worked, we have been able to get lawyers to come on board for free. Then there was the question about the word juvenile being used all over. It is true, it is used everywhere, but our Children's Act itself, the people who made our Children's Act, who sat and debated it and passed it, saw it fit not to include the word juvenile in it, the term juvenile in it. And that act was actually domesticating the UNCRC, the African Charter, that one on the rights of the child, welfare and rights and welfare of the African child, that, and all the other international instruments related to children. But for some reason, and that's what maybe the researchers in this room will do, our parliamentarians or the people who presented the act decided that the word term juvenile should not be in that law. And in my view, it's because all along it carried a stigma with it, that any child who was called a juvenile, there was something not good about it. And then finally, okay.
Somebody wants to read one sentence for her, and then
yes,
she responds.
Thank you. Yes. Yes. Yes.
Okay, good morning, Judge. I just wanted, it's section 186B.
Yes.
Guarantees to a child accused of an offense. So
Yes.
it says, every child accused of having infringed any law shall be, if he is unable to obtain legal assistance, be provided by the government with assistance in the preparation and presentation of his defense.
Yes.
So it's the government.
Yes. But with money provided for by the government. So if you are in my court and you are the wakili, and I say, wakili, please represent child Bidali here, and no money has been given to me to pay you, are you seeing the quagmire? The government is supposed to do it. So who is supposed to move the court to make a declaration that the government should do something? You know, so you make the orders, but where will the money come from? That has always been the challenge. That, of course, the lawyer might say, okay, I'll represent and sue the government to pay me. That is the other route one can take and say, okay, I'll take the brief, then I'll sue the government to pay me my fees. You see, you get it? Yeah, so that is where the challenge had always been with children, that it is there in the law, but it's a paper right. Yeah. So the other thing was about mental assessment. No, not mental, the issue of the VPA, the Victim Protection Act. Again, the fund has not been set up. So if it was there, it would be so easy because it provides for how a victim can actually be compensated. But now we are left with the system that works, that you can sue that person and get compensation from the person who has committed that crime. But the moment that fund is set up, then it becomes easy for victims to get the assistance they need. Then I think the issue of mental assessment, Prof made a comment, and I don't need to add anything to it. Otherwise, I think that was all. I want to thank you very much for listening to me and for the very good work that I'm sure we are going to do at the end of the day. I just hope that we can come up with very practical ways of making it very easy for a child to get a legal aid. Thank you.
Thank you so much, Lady Justice Madeka. Let's clap for her properly. Who can we? Asante sana. And now, I don't know what time is tea time, but we have an announcement to make that anyone who is leaving today, wants to leave today, should actually check out of their rooms as soon as possible and get in touch with Mr. Mutembe standing back there. So I would want to take this opportunity to invite Professor Michael Wabwile to take us through very, very briefly, because we have discussed this topic now for a long time, the emerging problems in Kenya, in Kenya child support law and practice, the potential limits of legal aid. Prof, very briefly.
Okay. Yes, good morning, colleagues. Yeah, okay. This topic of child support is very close to my heart. I've been researching and studying this for close to 20 years now. And my manager, program manager tells me I should be very brief. So I don't know what justice I can do in less than 10 minutes, but I'll try my best to make a presentation. There's a typo on the topic. We are looking at the potential and limits of legal aid for child support. So it's not potential limits. It's the potential and limits. I think there's. So it is the potential and limits. In other words, we are looking at what we can achieve using the mechanism of legal aid for children who need interventions to access financial support from their parents or families, and what are the limits of the existing systems for legal aid in the context of child support. And generally, when all is said and done, we also look at the limits of law. So now let me try introduce the concept of child support. What we mean here is that each child has an interest to access the basic decencies of life. So we are looking at child maintenance, financial support interests, and the developmental rights of every child. So in order to understand this, I think, sorry. Yes. Let me look at this slide. Now, we look at this, let us look at this slide. You can see this, the smallest zone, we are looking at the family capacity to provide financial and resource needs of the child. So the child is born, no, the child does not belong to the universe or to the cosmos. The child, first and foremost, belongs to a small community called the family where the child is born. That's where the child has an identity and is nurtured. That is the first line of financial support, or what you call child support, is at the family level. So that's where we get our identity, our socialization. You belong to somebody, you don't belong to the cosmos. You belong to the family in the first instance. Then the second line is now the national community. So then we go to now the international community. So child support can be seen in that context of a network of obligations at private level of the family and public level where we now have the state and even the international community. So we do not expect that the state and the public should replace what families should do. So ideally, majority of individuals are nurtured and raised by families. Then the state has the obligation to enforce parental responsibility and also to assist families to address their obligations towards children. Then the international community, you look at the structure in the Convention on the Rights of the Child, there are supplementary obligations of the international community to assist states so that states can discharge their duties towards parents and families. So it's a kind of network. So we then look at now child support in this context of enforcing the private obligations, private law obligations of parents and families. So normally, for majority of children, families come through for them. They just grow nicely in the family situation, and they do not need legal aid. But the problem is, we need intervention of legal aid when something fails to happen, and that is, we get to a point of what we call family breakdown. Courts and the public will not intervene in an ongoing family relationship. It is when there is a situation of breakdown that structure I've described of the family to look after children is no longer functioning. That is when now we have to look at how to intervene through the processes of the law, and that's how legal aid comes in. We are looking at typologies of family breakdown which then trigger the need for intervention. We have things like, for example, separation of the parents. This can be de facto or by way of a legal process, like a separation agreement or a separation order, or just somebody waking up and packing everything and going away. We are facing very interesting times. Now you find a lady comes to the legal aid clinic and says, my husband has packed everything, including my clothes, and cleared the house and gone with everything. I don't know where he has gone to. I am left with the children. I don't even have a sufuria to make porridge. So that's a family breakdown situation, separation. We have divorce, death of a parent. Then relationship breakdown also, where there is families, we have families outside marriage, and when the going is still good, things are working. For example, when a sponsor is looking after his child, you call them sponsors or baby daddy. Baby daddy is doing well until the mistress has another pregnancy and another child by another man. Now that becomes a big issue because now the money doesn't come. But the question is, what is the problem? Because every person should bear their own burdens. So if there are two children with different fathers, everybody should bring child support for their own burdens. Or so, as the scripture says, everyone shall bear their own burdens. But so there's a relationship breakdown, and you look at the principle of non-discrimination. So the Constitution sets out the standards of parental responsibility, that whether the parents are married or not, the child should not be disadvantaged by the matrimonial status of his parents. So then such fathers get annoyed. They fail to realize that child support obligations are separate from the status of the relationship. So then we have a problem there of relationship breakdown. Now let's look at what kind of legal aid we do in this. What kind of legal aid do we do in child support proceedings? 60% consists of legal advice. People come in the clinic or in your law firm, or then you explain to them the rights of the child, their obligations to the child, parental responsibility, their options and practical steps, so that you give them legal information to defend their rights, to assert their rights, and to address their duties towards the children. So a man walks into your chambers and says, "Madam has gone with the children, what do I do? I'm not going to pay any money for child support unless I can see the children." I say, no, you don't do that. Your right as a parent should be distinguished from your duties as a parent. First of all, make sure the children have access to financial support first, so that they are alive for you to see them. So then we separate the breakdown from the duties towards the children. Then we also provide support for self-representation. For example, drafting a demand letter, drafting pleadings, affidavit submissions, formulating the content to get it to the children's court. Then the parties can file in their own name, because most of the legal aid centers may not take up the representation duties immediately. So you do for them pleadings in their own name and they file. You do for them submissions and they file. You do for them affidavits and they file. Finally, 10% legal representation. That's where you take up the matter, take up instructions, and get the work done in court. Let me talk about the potential and also what are the likely impacts. Now, on the potential, I want to say that part of this conference is to try to encourage advocates to provide legal aid for children needing assistance with child support. For example, one of the reasons why we think this is a good thing to do is that we can actually graduate from a general legal aid clinic to more specialist legal aid centers. For example, what I'm calling a child support center, for example. So instead of just running a legal aid program, we can just have a child support center, which is like the first port of call for anybody with a child support claim, including those who may So we are advising colleagues and organizations trying to provide legal aid that we can actually progress from a generalist legal aid program to small specialist things like a child support center. So then if you have a claim for child support, you come there. So we have then specialized in just collecting money for children from maybe disengaged parents. And this has a lot of potential because we can then improve outcomes for children. We can also look at the balance of power because now sometimes the absent parent has more power in terms of financial capacity than the one remaining with the custody of the children and says, where will you take me? And we can say, we have a child support center, please let's meet there for mediation. And then in the mediation meeting, we agree, all right, even the approach to practice in child support work ought to change. Like when you write a demand letter to a father who is not living with the child, there should be a different tone from when you do a demand letters for a commercial dispute. So for example, you can then insert the bank account details for the child's account, politely and gently reminding the respondent of his obligations towards his children, and reminding him that, you see, these children need parental care and love. So the letters we do in this practice should be specialist, not the way we do general demand letters like other claims, because we notice that there's a lot of high potential for success. When you interview a parent who has been given a demand letter, he tells you, I love my children. The only problem I have is the mother. Otherwise, I have no problem with maintaining my children. I love my children so much. So why are they writing to me a letter like this? We say, all right, cool down, sir. Now, how much would you like to pay? Then he says, look, I have no problem with money for my children. So there's a high potential for success in practice in child support legal aid. Then we also think that these interventions in child support can actually help to reach mediated or negotiated settlements. To me, in my own practice and the counseling I give to clients, there is no reason why a parent should be served with a court order to maintain his children. So we can actually avoid court orders because these are the children of the respondent. They are not strangers to him. They are family to him. So there's potential, if this is an area of practice that we should be going into to provide legal aid, knowing we can succeed. I've also put in my presentation that robust enforcement of parental obligations and child support duties can lead to behavior change, because if you know there's a very active child support center in the community, you know you'll be taken there. And you know people will talk to you nicely and you'll be invited to pay. So in that way, people will think twice before they think about activities that may land them in a child support center. So it may actually have an impact on behavior change, parenting behavior. Finally, we have problems with our approaches. One of the problems we have is that not many people want to offer pro bono legal aid to child support for child support cases. And our argument is that child support is one of the most exciting areas of legal aid because you are looking at investing in the future. These children are a resource. You go to Kabarak and they say, on earth we rise. These kids are rising, and 20 years after you get that order, they are going to be very powerful people, and they look for you and they say, hey, you are our heroes. You helped us when we were losing money. Our father was not thinking clearly because of the stress of relationship breakdown. You are our hero. And I tell them, no, don't say a word. Praise be to God. Praise the Lord. So the other problem we have is that some of the NGOs offering legal aid for children tend to have problems with their own mandate and what the donors want them to do. So you find they do what the donors are telling them, or what they want to impress donors so that donors can see. So instead of just going to the children's court and obtaining an order for maintenance, you find an NGO with very good funding going to the High Court to contest a public interest litigation matter to try to strike out an act or a section of the Children Act. Remember the case of Ross Mora and the Attorney General, which was one of the historic cases challenging the constitutional validity of the Children Act. I've looked at that case, the judges said, sorry, the Children Act is not unconstitutional, you just need to know how to use them. To use it, just go to the Children's Court, ask for a maintenance order for a child born outside marriage, and you'll get it. But the NGOs don't see that as being high profile. So they do a high profile case, which they lose, which does not help the child because of what I call donor capture. So donor capture is a serious problem in what we are doing. But I may also say that legal aid alone may not actually fix some of the problems we have. And so then that means we have an explosion of teenage pregnancies, which was in the media recently. When you investigate, you find we are dealing with a teenage father of 17 years. How do you deal with this now? A teenage father of 17 years, he already has 2 children. Now, how will we even take this one to court? So it means the grandparents are the ones going to raise this child, and yet they are paying full income tax. Can we review our policies towards child support? I'm happy to see that there's a draft bill by the MP for Thika Town, the Legal Aid, the Child Support Act. I think we should have conversations about this. Dr. Sen, I have so much to say about this topic, which I've been researching for 20 years, but I have to stop. I have to stop now. We can pick up this in due course. Thank you.
Thank you so much, Professor Wabwile, for bringing up a number of issues, especially that issue of teenage pregnancies, especially during this COVID-19 period. It's a real problem, especially among marginalized communities. Let's now have a change of topic from just child issues by inviting Dr. Charles Kamala to take us through the effectiveness of victims' legal representation in Kenya's post-2007 election violence. You have 10 minutes, sir.
Good morning, colleagues, ladies and gentlemen, all protocols observed. Karibuni, it has been a very informative morning and also yesterday. I'm honored to be able to contribute something from the perspective of victims of crimes, not so much suspects. I know that we defend suspects in the courts and there is legal aid for suspects because the state has disproportionate power. But primarily, they're also victims, and particularly in mass offenses, mass atrocities, where you have 1 million victims, 500,000 or hundreds of thousands. There is a distortion in the criminal justice system that changes the dynamics, and I'll try to allude a little bit to the background as to why we need legal aid for victims. So that by the conclusion, I'll be explaining that we have what is called a Victim Protection Act, it was mentioned in the morning, where there's a Victim Protection Fund. And I was going to tell the judge that when she was saying what the government does not have any provision. There is a Victim Protection Fund. I won't speak so much about the Legal Aid Act. I know about it, but it has been spoken so much about and much will be said more about it. So there's a last section of my paper which says that, but I won't speak about it. What I intend to the problematic which I'm concerned with is, number one, the fact that there were many victims of post-election violence, and you know the debate has reemerged. The Director of Criminal Investigations, or the DCI, has mentioned that he has 118 live cases or victims who have given statements to him, and he's concerned as to whether to prosecute and what to do with them. So that debate is going on, but the Kenyan cases before the International Criminal Court were vacated for lack of cooperation with the Kenya government. So there are Kenyans who feel they don't have justice, and that's a bad society. If a good society is one where people have jury care. So that is the core of the problem, and we want to understand why that is the situation and what can be done about it, and what attempts have been made and how those attempts may be improved, or at least to evaluate them. Were they effective to achieve victim satisfaction? And if not, why not? The approach I intend to use is to begin with a dispute about who should represent and articulate victims' rights. Should it be the office of the Public Counsel for Victims in the ICC at The Hague? Or should it be an external victims representative, a common legal representative here in a situation country? And ultimately, neither worked in the Kenyan cases. So what we do have are civil claims for reparations, which is different from a criminal conviction. But I'll explain that problematic and how it has petered out, and I end up concluding that maybe the victims in the Kenyan situation prefer compensation, money, damages, rather than a conviction of senior political and military leaders who may have perpetrated crimes. How will conviction assist a victim? And the problem with retributive justice, which seeks punishment, it assumes that there's a symbolic remedy or satisfaction which accrues to a victim on account of a conviction. And the question then becomes, what are victims' interests? What amounts to victim satisfaction? And these are multiple because there are many victims. You have hundreds of thousands of victims, conflicting interests. Some victims, reparations, compensation, memorialization, commemorations. Memorialization and commemorations are, if my relatives have been lost, I want a statue so that I can remember them, or a day when we're going to have a post-election violence day, and I'll remember my relatives. Some want hospitals to be built, or schools, but in the Kenyan cases, victims were saying, look, we don't want to coexist with the perpetrator community. We want money so that we can move from where we were displaced and go somewhere else. So the conflict and the problem that arises is, if you let all the victims participate in the case, it will prejudice the suspect. The suspects will not get a timely trial. They will have to face so many victims, not just the prosecution case, and you'll convict a suspect who may be innocent, but simply because they are embarrassed and they can't logistically investigate all the cases that are being brought against them. So we can't let everybody participate, and we can't know every victim's personal interests. And that's where the problematic then arises. So who is going to articulate what is the victim's interest? Because the harm has been suffered, and that's where the problem starts. When you start with Nuremberg and Tokyo, these are the 1945 World War II international military tribunals, victims were appendages. They were simply witnesses who signed statements and were appendages in a criminal trial which convicted and executed some of the perpetrators of genocide and atrocities. But with the modern International Criminal Court, there has been a realization that victims who are ranging them, more than 100,000 or even millions, must be put at the centerpiece of the international community's interest. So the question then becomes, victims, who is a victim? How do you define victimhood? The first thing about victims is, victim is not contingent upon conviction. A criminal is a suspect is a suspect until proven guilty, and then you can call them a criminal. But a victim exists right from the outset. It's not contingent on the process. And that is simply by the UN Declaration of 1985 on victims' rights and also victims of abuse of power. So that's one entry point. But at a procedural level, the International Criminal Court is the first court in the world where victims' counsel are given space in the bar. They can sit within the court, cross-examine, now basically influence the course of the trial. And that has major ramifications on the rights of a suspect, as known in an adversarial trial. So the adversarial trial, which the goal of the trial is innocence or guilt of a suspect. Period. There's nothing else that the purpose of the criminal trial is designed to do. Yet, when we front case the rights of the victim, because they are important, because there are so many of them, then there are those problems which I've alluded to. There's the danger of the suspects being convicted because they have been prejudiced. There's no equality of arms, and they don't know which case they are facing. Are they facing the victim's case, or are they facing the prosecution hypothesis? But how does the International Criminal Court try to balance? That's the role of the judge, to be a manager and to balance how to accommodate victims' concerns to reparations, and that's a civil law or inquisitorial function. The victims are concerned with the truth. What actually happened? What is the scope of the harm? And can I receive some compensation? That's on one hand. And the judge is trying to balance that, and you cannot get to reparations unless you have victim participation. So to what extent and at what stages are victims permitted to participate in the trial? And I'll give a small procedural indication about that. But eventually, if it doesn't work well, what happens is victims will not have their voices heard in the court. It will only be symbolic. It will only be a pseudo voice. It will be the voice of their representative who is purporting to represent them, but is actually articulating whatever they want in order to even further a conviction, but not to further what the victims really experience. So how does it work out so that you can get the victims to have their voices heard? So to cut a long story short, the previous approach was you have to apply to the victims' participation and reparations section of the registry in a 17-page document. It was reduced to 7 pages. It was reduced to 1 page. In the Kenya case, there was a different approach which didn't even require an application to be made. What does the rule say about who is a victim? A victim is the following things. Any person whose interests are affected by the outcome of the case may be permitted by the court to present their views and concerns at an appropriate stage of the proceedings, provided it does not prejudice the accused person. So that's Article 68 of the Rome Statute. How that is applied in practice is as follows. Even before, when there's a mass atrocity which happens, everybody who thinks they're a victim, and there can be, hundreds of thousands of people, writes to the prosecutor or the registry of the ICC saying, I am a victim and I want to participate. They'll have to be screened. And after the screening, certain cases will be selected and people will qualify as victims. And only those people who actually participate in the case will be entitled to reparations. What that effect does is, if an individual is identified as a victim, not simply of the situation country, but eligible to participate in the case, then they will be allowed to introduce their views and concerns at an appropriate stage. Then when it comes to the reparations part, if there's a conviction, they'll submit on victim allocution, how they were affected, and then they will get compensation at the very end. It's a long process, but the difficulty with that is it's very few people who will get the reparations at the end. If it is the Office of the Public Victims Counsel at The Hague who is doing the representation, he will select different victims. And he will classify them differently. Rape victims, victims of loss of property, murder victims, victims of police shootings, and they'll classify, and the prosecution will decide which cases to actually take before the court. And if a case is identified as the charges which we can prosecute, those ones will qualify, and there's a select number of victims who will actually emerge as entitled to participate. Yes, I'm aware of the time. What happened in the Kenyan cases is that ultimately the court decided that it must be a local advocate. It was our colleague Wilfred Deritu. He took over from another advocate who was in the UK, and there was some representation, but at the end the cases were vacated, and I don't go into the history of that. In the local cases that we have had 3 cases ongoing against the ICC. One, I'll talk about, and this will probably be the last few things that I'll say, to see how, although there was no reparations which happened from the ICC cases, there have been some compensation awarded by the Kenyan courts in one of the cases. One was decided yesterday, I still don't know the outcome, and one was dismissed. So first I'll start with the case of Joseph Kibiwot Meli, 2018. Joseph Kibiwot Meli was from Nandi County, and with others, they sought accountability. They want to see the registry, the register, and an account of who has been allocated land, who has been given compensation, because it was unclear to them. It's under the IDP and Affected Communities Act. But their case was dismissed because they did not qualify as an IDP, person affected under the Act. They could not show that they were forcibly displaced from their property by human rights violations. There's a certain definition of who qualifies as an IDP to be entitled to compensation under the IDP Act of 2012. They didn't qualify and they were not given their remedies. The second case is CAVI, which is Citizens Against Violence, and 15 others, including the Independent Medical Legal Unit, which is the Kisumu shootings case. Kisumu shootings, you can look at, you saw on KTN, there was a Rambo policeman who was shooting some youths at close range. But basically, 405 of the post-election violence deaths, which were 1,133, 405 were for police or gunshot wounds attributed to the police. So the first case in 2013 was about Kisumu. Only 3 out of the 13 petitioners were compensated. The other cases, they didn't see the police actually shooting. What are the kind of claims that they are making for the violations of their rights? Violations of right to life, security of the person, torture, effective remedy, right to information, equality and freedom from discrimination, and finally the right to protection of the law. What rights were being recognized are 2, basically, for the 3 who got their remedies. The right to an effective remedy and the right to information. That is what Judge Fred Ocheng in the Kisumu High Court awarded, and only for one of them was for who actually was able to adduce that they saw the police actually shoot and there was actual evidence. Remember, the reports are being made months late. The shooting takes place in December. The reports are being made in May or June of the subsequent year. Now, so the difficulties which victims have in receiving a remedy, the final case, as you know, which was decided yesterday, is Kovo, which is sexual violence, gender-based violence at Naivasha and Nakuru, which is Kovo as the NGO on behalf of victims. I don't know what the decision was, but the remedy which is being sought is, why did the police fail to prevent the violence, and why didn't they prosecute known suspects? It's another discussion as to why the police, under common law, are never liable for failure or negligent failure to respond to any call for protection. But we'll discuss that in another context, maybe if we ask questions about that. But in a nutshell, there is need for legal aid, and the paper is able to conclude that there is justification if the International Criminal Court can provide legal, or one of the donors who is supposed to give funding under the the Victims Protection Fund. There's funding which is required from various sources, including donors. If there is legal aid supplied to the victims of post-election violence, there is a possibility of getting compensation at domestic courts because we have that precedent. And at the international level, there are difficulties which afflict representation because of the distance and because of lack of information which comes to the victims from the international courts and the lack of coordination between the common legal representative at domestic level, who is an external advocate, and the office of the public victims at The Hague. I represent those problems that are happening which do not give effective legal representation, and a case that can be made for compensation to be sought. And even if it's in lieu of conviction or criminal justice, maybe that's what the victims want. Maybe that's what gives victim satisfaction. And ladies and gentlemen, I thank you for your attention.
Thank you so much. Thank you so much, Dr. Kamal. I think that was very, very interesting, especially since the post-election violence is still an issue that is very close to our hearts. Thank you, Stu, for taking us through who is a victim, what are the interests, is it compensation as opposed to conviction? Wakenya wataenda gani? Compensation or conviction? Wakenya si wataenda kwa pesa, si ndio? So Dr. Kamala, if you want to find him, you'll find him in African Nazarene University. But then I also forgot to mention that Professor Wabwile, besides being the founding dean of the Faculty of Law, Egerton University, is also at the Kenya School of Law Board and also at the Law Society of Kenya Disciplinary Committee. So if you need him, he's there. So the last speaker for today.
What's the one thing? It's one sentence. Ladies and gentlemen, with your indulgence, I have a book which is available, and I'll display it. Thanks for the plug. But that I forgot to say, but while I'm on the floor, I'll just let you know that much of what I've said is elaborated in the context of a book. Thank you.
Thank you so much. Promoting by that book. I hope you brought a few copies for sale. So now I want to invite Maurice Odwor to discuss the informal justice structures and the protection of matrimonial property rights, a topic very close to our hearts. Matrimonial property rights of widows in rural Kenya, reimagining justice and legal aid. And that will be the last speaker before we go for tea. Maurice, karibu.
Thank you, Mr. Wambua. I hope you're Mr. Wambua? Sena, sorry. I don't want to come between you and your tea and mandazi. So I'm not going to take a lot of your time. Jane, not her real name, lost her husband, and her story was highlighted in one of the daily newspapers on 1st July 2020. Her husband died in an accident. Now, immediately thereafter, her in-laws blamed her for the death of her husband. And they kicked her from the home that she shared with her husband. They took over property that they had made in the course of their marriage, and they stopped her from attending. They threatened to stop her from attending the burial. She had to get protection from police to attend her husband's burial. A few weeks down the line, her son would ask her, "Mommy, when is Daddy coming back from work?" She did not have an answer to that question. And she would be stung in her heart whenever the child asked her that question. But more importantly, she would feel very hurt because of what her in-laws did to her. The critical point is that she was unable to seek any protection from what we call the law relating to matrimonial property. So she let go. She left the village, went and lived in town with her child, notwithstanding that there was property that she could have access to for purposes of taking care of her daily needs. Mary used to live with her husband in Nairobi for a very long time. They had not built a home in the village. Her husband died. Then she chose to go back to the village and claim what she believed was her right. She went to court, obtained injunctions and whatnot, the usual camaraderie of litigation and whatnot. And she got orders. And she was told, sit here, build your house. And she went ahead and did that. And there was a lot of tension between her and her in-laws. What happened next was very sad, and we attended Mary's burial sometime last year. She is the mother of a colleague of ours in the legal profession. Mary was killed, and her body was badly mutilated. And it became clear that the people who did that crime were her in-laws, her brothers-in-law, and they were arrested. The case is still going on. But the way they dealt with her body, they left no doubt of the hatred that they had for her for attempting to challenge them. Because she had left the village for 20 or so years. She came back and she tinkered with the balance of power that was at the village at that point. And she used the legal processes to bring her back to the land. There's a story that was carried in the Standard newspaper on 21st of June 2017, which dealt with, and the title of that story was that widows are left at the mercy of in-laws and, critically, the courts. Widows left at the mercy of in-laws and the courts. So we've reached a point where even though we have legal systems and institutions that we can use for protection of widows, those very institutions and those very legal systems actually victimize widows. And so one of the respondents was asked, why would she not seek justice in the courts? And she said, most widows cannot afford court cases. If anything, they are time-consuming and are culturally frowned upon for family disputes. Going to court worsens the relationship between widows and in-laws. How do you go back to such a home after winning a case against them? And ladies and gentlemen, that for me is a critical issue. When we set up judicial systems, when we set up the courts, when we define Article 48, access to justice, whose justice are we talking about? Is this justice that serves the interests that are down there on the ground? Because if you look at the theory, the theorization around the concept of justice as contained in our statute books, we have characterized justice in two ways. Either as a good that is there to be distributed by the state, or as a system of rights. In each case, we are assuming that every individual has got the same capacity to go out and seek the protection of the courts and the judicial system. And that is a problem for me. It is a problem because when you look at the legal aid projects that we've had in this country, it is premised around the notion that we are taking justice closer to the people. But then again, what are the problems that we are resolving? As Bidali told us, when they were doing their study, they did not find a law firm was it in Tana River? There was no law firm in Tana River. There are no courts. There are no resources to access these courts, and so on and so forth. But how are we problematizing? What is the problem that we are resolving? When we talk about justice, are we only talking about lawyers? Are we talking just about courts? Are we talking about, being able to get an injunction against a party that is violating a right, and so on and so forth? And so, for me, the beginning point is to look at to define the problem in a way that takes us to the heart of the solutions that we need on the ground. And so when we equate justice to lawyers, when we equate justice to courts, when we equate justice to judges, statutes, and so on and so forth, I think we are losing the point. There are far more important issues to talk about on the issue of what justice is. And in the question of matrimonial property rights, we have assumed that widows can use Article 48, go to court, and seek to protect what their interests are. We've seen that that does not always happen. And we now have a situation where we have a constitution that attempts to sort of make the situation better by allowing us to apply alternative justice systems. But again, my other question then is, when you talk about alternative justice systems, what exactly are you talking about? We have a project that is being carried out through the judiciary, the AJS project. And we are looking at alternative means of enabling persons to access justice. But my problem with that approach, again, is that we are attempting to formalize the informal, as Professor P.L.O. Lumumba has already said. And there's been a criticism of this tendency for our courts, this tendency of our courts to attempt to sort of hijack what I would call local understandings of justice, as well as local institutions of justice, and bring them over, to the formal legal system, and then mischaracterize them. When we were studying, we read a book by Eugene Cotton, The Restatement of Laws of Kenya, a book that was written very many years ago. And we saw situations where courts were actually referring to the customary principles of law that were set out in that book as though they were representing what the current structure or the current status of the law was. But that is a problem, because then when you write down these laws and you set them down in books and you act as if those books are what represent what customary law is, then you ossify those laws. You sort of mummify them so that you deny them the ability to grow and to change in accordance with the circumstances. And so, for me, when we talk about legal aid, we must recharacterize what is our understanding of the justice that we want to achieve. So that legal aid must go beyond just the courts and whatnot, the judges, the lawyers, and so on. And this is not something that cannot be done. It is something that is actually being done. There's an organization known as KELIN. KELIN has been doing some pretty good work in Homa Bay and Kisumu. There's a project they call Cultural Structures Project, where they use already existing institutions in the society, in the communities. And I know it has been argued that sometimes some of these cultural institutions have the tendency to perpetuate certain inequalities and so on and so forth. But those are things that can be dealt with. They can be dealt with in the sense of training the players in those cultural structures, so that when they make decisions that, again, do not violate the fundamental principles of the law. And so the conclusion I'm making, ladies and gentlemen, is this: that yes, there's a need for justice, that yes, we have problems insofar as the protection of the rights of our people on the ground is concerned, but we cannot take it upon ourselves as lawyers, judges, magistrates, courts, and whatnot, to define what justice is for the people who will seek it. That is one. Secondly, even as we talk about legal aid, we must talk about legal aid in a manner that makes sense to the people who are going to use it. In the case of widows in rural parts of this country, there's a potential for utilizing some of the structures that they are familiar with, and this has been seen. And very finally, even as we seek to intervene in those spaces, we must find our intervention must be such that we utilize what is already existing there, and just take care to ensure that when we allow them to utilize what they have, they do not do so in a manner that violates the Constitution. And that is something that can be done through training and enhancing their knowledge, the knowledge of the players in those spaces, to issues about non-discrimination and constitutional rights, and so on and so forth. Thank you very much.
Thank you very much, Maurice, for that very beautiful intervention. Yeah, it's true that there's need for justice, but whose justice and who defines it? There's also a need for us to discuss the structures for delivering justice and seeking justice. And even though we utilize very, very big debate. So I think we will go for tea, and then after tea, our first speaker will be Ms. Anne Katonya, addressing the challenges of providing legal aid through university clinics. Thank you so much, and maybe 15 minutes for tea. Is that okay? Yeah. And then after we'll do a few more presentations.